A new dawn has broken in the Indian justice scenario as the country embraces three revolutionary criminal laws, poised to replace the long-standing British-era codes. This monumental change comes as the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act make way for their successors. The Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam respectively. The Bharatiya Nyaya Sanhita, set to replace the Indian Penal Code, boasts 358 sections, a reduction from its predecessor's 511. The Bharatiya Nagarik Suraksha Sanhita, on the other hand, inheriting from the Code of Criminal Procedure, will carry 531 sections, an increase from the original 484. The Bharatiya Sakshya Adhiniyam, taking over from the Indian Evidence Act, will consist of 170 sections, a slight increase from the former's 167 sections. These new laws, recently passed in Parliament, are scheduled to come into effect from the 1st of July. Each of them carries a host of changes, additions and amendments, all aimed at revolutionizing the Indian justice system. The Bharatiya Nyaya Sanhita, for example, introduces 21 new offences, increases imprisonment terms for 41 offences, and introduces mandatory minimum punishment for 25 crimes. On the other hand, the Bharatiya Nagarik Suraksha Sanhita introduces 9 new sections, repeals 14, and changes 177. The Bharatiya Sakshya Adhiniyam amends 24 sections, adds 2 new ones, and repeals 6. These new codes are not merely a reshuffling of the old laws. They represent a significant step forward in aligning India's criminal justice system with the evolving needs of its society. They aim to modernize the language, expand the scope of criminal trials, and redefine standards of evidence, moving away from the archaic and often criticized British-era laws. These laws aim to modernize India's criminal justice system, moving away from the shadows of the British era. The Bharatiya Nyaya Sanhita, replacing the Indian Penal Code, introduces a myriad of changes. As we delve into the intricacies of this new law, we find it has been fine-tuned to reflect the evolving nature of crimes and punishments in our society. With a total of 358 sections, this new code is more streamlined than its predecessor, which had 511 sections. However, don't let the reduction in sections fool you. The Bharatiya Nyaya Sanhita is more expansive in its coverage, with 21 new offences added. The imprisonment term for 41 offences has been extended, penalties have been increased for 82 offences, and a mandatory minimum punishment has been introduced for 25 crimes. One of the most notable changes is the repeal of 19 sections, showing a conscious effort to remove outdated or redundant laws. This is further reflected in the replacement of archaic terms like lunatic, insane, and idiot with more compassionate and accurate language. The definition of cruelty has also been added, offering a more precise understanding of what constitutes this offence. The Bharatiya Nyaya Sanhita also takes a step forward in acknowledging and addressing societal issues. The law now includes a special emphasis on crimes related to human body and dignity, such as rape, gang rape, crimes against children, murder, kidnapping, and trafficking. A new chapter dedicated to the safety of women and children has been added, marking a significant stride towards protecting these vulnerable groups. Lastly, the new law brings the much-needed attention to the contemporary issue of mob lynching. With the introduction of a provision related to the death penalty in cases of mob lynching, the Bharatiya Nyaya Sanhita sends a clear message that such acts of violence will not be tolerated in our society. The Bharatiya Nyaya Sanhita brings a fresh perspective to crimes and punishments, addressing contemporary issues like mob lynching. This new law is not just about change, but about evolution, a reflection of the society we live in today and the society we strive to create for tomorrow. The Bharatiya Nagarik Suraksha Sanhita, replacing the Code of Criminal Procedure Act, ushers in a new approach to criminal trials. This new law is a significant overhaul of its predecessor, boasting 531 sections compared to the previous code's 484 sections. It introduces 9 new sections, repeals 14, and modifies a whopping 177 sections. These changes are not merely numerical. but significantly alter the way criminal trials are conducted in India. A major change is the restriction on the use of handcuffs. Handcuffs are now limited to heinous crimes such as rape and murder. However, the police's power to use them has been expanded to include court visits, striking a balance between the rights of the accused and the safety of the public. Another significant reform is the revision of police custody duration. The 15-day police custody can now be sought as shorter periods of custody over the entire period of investigation, which can range from 40 to 60 days. This offers a more flexible approach to investigation, adapting to the needs of each individual case. The Bharatiya Nagarik Suraksha Sanhita also introduces new provisions for FIRs. The concept of zero fear and e-fear have been introduced, along with a preliminary inquiry before fear registration in certain cases. This helps streamline the process, ensuring that every complaint is promptly and properly addressed, and that the FIRR registration process is more transparent and accountable. These changes highlight a shift towards a more humane, flexible and efficient criminal justice system. The Bharatiya Nagarik Suraksha Sanhita acknowledges the evolving nature of crime and society and adapts accordingly. It aims to protect the rights of the accused while ensuring public safety and maintaining law and order. This law aims to streamline and modernize the criminal trial process, making it more efficient and in tune with the digital age. The Bharatiya Sakshya Adhiniyam, set to replace the Indian Evidence Act, introduces new standards for considering evidence. This is a monumental shift in India's criminal justice system, bringing it up to date with the digital age and acknowledging the shifting nature of evidence in the modern world. The Bharatiya Sakshya Adhiniyam consists of 170 sections, a slight increase from its predecessor's 167. The existing Act's 24 sections have been amended, 2 new sections have been added, and 6 sections have been repealed. These changes reflect the evolving landscape of crime and justice, necessitating a fresh approach to gathering and considering evidence. A key change in the Bharatiya Sakshya Adhiniyam is the introduction of more stringent standards for considering electronic and digital records as primary evidence. In the age of smartphones, social media, and cloud storage, digital evidence has become increasingly relevant. The new Act acknowledges this shift, placing an emphasis on the proper custody, storage, transmission, and broadcast of electronic records. In addition, the definition of a document has been expanded to include electronic records. This is a significant move, recognizing the increasing prevalence of digital communication and record-keeping in our society. It reinforces the importance of digital evidence and ensures its proper consideration during trials. The Bharatiya Sakshya Adhiniyam also legalizes conviction based on the corroborated testimony of an accomplice. This is a significant departure from previous practices, and it's a change that has the potential to transform how criminal cases are approached and resolved. In conclusion, the Bharatiya Sakshya Adhiniyam ushers in a new era of evidence consideration, embracing the digital age and its implications. It acknowledges the changing nature of crime and evidence, and it equips the justice system with the tools necessary to navigate these changes. The Indian criminal justice system is stepping into a new age, and the Bharatiya Sakshya Adhiniyam is leading the way. Like any major change, these new laws have not been without criticism. Critics and opposition parties have voiced concerns, particularly around the potential impact on the most marginalized sections of society. The fear is that these new laws, while promising in their intent to modernize and streamline the Indian criminal justice system, could have unintended, disastrous consequences. A significant concern is the potential for misuse or abuse of these laws, especially in cases where law enforcement and judicial discretion come into play. With the new codes, the definitions of many offenses have been broadened and penalties have been increased. This could potentially lead to more severe punishments for offenses that were previously considered less serious. Moreover, critics argue that the laws have been introduced without adequate public consultation or consideration of their potential social impact. This lack of transparency has fueled concerns about whether the new laws will be fair and just, especially for the most vulnerable and disenfranchised members of society. While these concerns are valid, it's also important to remember that any major legal reform is a process, not an event. The effectiveness and fairness of these new laws will largely depend on their implementation and interpretation by the courts and law enforcement agencies. As citizens and law students, it's crucial to stay informed about these changes and their implications. Understanding the nuances of these laws will empower us to engage in constructive dialogue and contribute to the evolution of our criminal justice system. In conclusion, India's new criminal laws represent a significant shift in the country's approach to justice. Whether or not these changes will prove beneficial in practice remains to be seen. As we navigate this new legal landscape, it's crucial to stay informed and understand the implications of these changes. Thank you for watching, and remember to subscribe and hit the bell icon to stay updated on our videos.